informed consent or patient consent, and patient confidentiality. At the most basic level, informed consent is providing the patient with relevant information to be able to make autonomous, informed, and educated decisions regarding their well being in healthcare. It is an extremely important aspect of healthcare and has been brought up in many legal cases against athletic trainers. The key term is the word informed. We need our patients to be an active part of the decision making process regarding their treatment and care. Patients need to understand all factors and options involved in their care and their rehabilitation treatment and return to play process. The Liability Toolkit from the NATA has been used to help athletic trainers. The Liability Toolkit suggests that athletic trainers have a detailed informed consent document that has been reviewed by a legal counsel to use with their patient population. It is also suggested that maintaining detailed and accurate documentation is a vital way to protect yourself from liability. Part of that documentation should be to indicate when, where, and how informed consent was received for treatment of our patients. Informed consent has evolved over time. It began with just getting the patient's consent, but made no mention of getting informed consent. It later migrated into informed consent, and it has since evolved into gaining the informed consent of a reasonable person. For example, if an individual is unconscious, this would be a situation in which the person was not able to provide informed consent, and therefore consent is considered implied, as the individual cannot give it based on their state. There are instances in which an individual is considered not in a reasonable state to provide informed consent. However, we are unlikely to encounter these situations in our current work settings. We do need to document these cases very well to protect ourselves if they do occur. If consent is given to treat one area or for a specific condition or injury or even for a specific treatment protocol, the consent is not a blanket statement. You need to obtain consent to treat other areas or conditions or injuries. We really should be doing this with every injury for each patient we treat. Informed consent is something that seems as if it should be fairly straightforward. We could ask patients if they consent to treatment or evaluation you know will help them. But it is much more complex. Informed consent decisions can be low risk or high risk. A high-risk informed consent process would be a scenario in which an injury, illness, or condition increases the risk of permanent disability or even death. A low-risk scenario could be changing small elements of a patient's rehabilitation program. We hope mostly to deal with low-risk to moderate-risk scenarios in our professional setting. The foundational principles of informed consent include ethics, legality, administrative, and risk, and the 5 components include disclosure, understanding, competency, voluntary, and assent. We will discuss each of these concepts individually. First, ethical considerations. Patients and athletes are under pressure, and a lot of the time they are making decisions that are not only good for them, but may also be good for their team, parents, recruits, and even other individuals. They feel that they may be letting other people down. You will commonly see sayings in athletic settings such as no pain, no gain, or there is no I in team, or here's a straw, suck it up, or even wussy, get back in there, or many other destructive phrases that I'm sure you have all heard at one point or another that can negatively influence a patient's decision-making process. Obtaining informed consent does not only help mitigate legal action, it also provides a value to the patient and the athletic trainer in the patient relationship. Informing a patient of the intended care identifies to them that you are there for them and to treat them as an individual. Not placing the no pain, no gain pressure on them helps you to develop your relationship with your athlete or patient. Informed consent also aligns with the NATA Code of Ethics and the standards of professional conduct. Different states do have different informed consent policies and specifically outline details of the informed consent policy. Under Texas law of a physician, Informed consent describes the physician's duty to disclose to the patient the risks and hazards of medical care that would influence a reasonable person's decisions to give or withhold consent to the treatment. While this is not specifically written for the athletic training population, as an athletic trainer or an athletic training student, you are operating under the direction of a licensed physician. Therefore, obtaining consent will also help in the defense of a claim of assault or battery. Informed consent allows the patient to be involved in the decision-making process. The shared process can help reduce your personal liability and potentially negative legal outcomes. With the patient's permission, the informed consent process allows the patient to bring others into the conversation regarding their health care. With the shared decision-making process, using informed consent allows the patient to feel like they are participating in a meaningful way. It will likely leave them feeling more positive about their outcome and more likely for them to accept responsibility for the outcome of their treatment. Currently, 27 states have specific statutes defining informed consent. These statutes generally consist of 5 elements: disclosure, understanding, competency, voluntary, and assent. Disclosure is the process of disclosing any and all information to the patient. If they ask a question about a treatment, you give them an answer or help them to locate an answer. This includes informing patients of risks, benefits, and alternative treatment options. Understanding is the patient's ability to fully understand the disclosed information. This may require using simpler language, using anatomical models, videos of surgical procedures, or possibly other resources. Competency is the ability of the patient to reason and process information disclosed to them. Does the patient understand the consequences of their decision? Do they weigh the options against short and long-term best interests with moderate and higher situations involving a minor? In the case of minors, a caregiver should be involved and must provide assent. Regardless of their age, a patient must provide informed consent voluntarily. They cannot be coerced or influenced by parties other than themselves. Assent is a positive response to the overall decision-making process. The patient must provide a positive response to proceed with the process, treatment, or even procedure. For low-risk scenarios, verbal assent may be acceptable. However, for high-risk scenarios or ongoing treatment plans, written documentation will be needed. Here is a chart of clinical decisions and informed consent strategies. We have different types of athletic training decisions: the level of risk, the informed consent format, whether verbal or written, and the proof of consent, which is a standard form. It may be an acknowledgement form regarding the ADA medication or even educational handouts. If you are giving a patient or telling them to take an over-the-counter medication, you can provide them with prepared documentation or education on hand. Or at the pre-season education orientation session that I encourage you all to include in your athletic training practice, you could address informed consent, particularly if you find yourself at the collegiate, professional, or even high school setting. If you are working in a clinical setting, you may not have the same opportunity to do so with your patient population. The proof of consent must be on documented medical records or with a patient signature. HIPAA and FERPA. HIPAA is the Health Insurance Portability and Accountability Act of 1996, also known as HIPAA. It protects health information that is individually identifiable health information. This includes demographic information related to an individual's past, present, or future physical or mental health conditions. Prior to 1996, we did not have the right to own our own health records, and you still may be charged a fee in some places to collect physical copies of your own health records. You will be required to complete a HIPAA consent to obtain your own health records, but you can do it now. HIPAA does not generally apply to schools. HIPAA privacy rules allow for covered health providers, such as high school nurses, to disclose protective health information for treatment purposes. such as when a student athlete falls ill during the school day, and you, as the athletic trainer, are trying to determine participation guidelines. FERPA, also known as the Family Education Rights and Privacy Act, has specific covered entities. This includes Texas A&M University Corpus Christi, but it may not include private institutions. There are different items that are covered under each policy, FERPA and HIPAA. FERPA and HIPAA. But specific to our context, it covers a good amount of private identifying information, as well as any medical or health record you create or maintain at your institution. Exceptions to this is if they are in a school directory health and safety, and exceptions also include emergency contacts or school official exceptions. Further into HIPAA, there are 5 rules, essentially 4 rules, and the 5th rule is the 4 rules combined. The privacy rule sets a national standard for protection of patient information. The goal is to protect information while allowing for a flow of information from treatment and payer information. It allows patients to examine and obtain access to their health records in any form they choose, and to ask that corrections be made to the information. The security rule establishes a national standard to protect individuals' electronic and personal information. This was implemented to protect the confidentiality, integrity, and availability of electronic personal health records. The breach notification rule requires covered entities to inform of breaches when protected health information becomes unsecured. There are different regulations as to when breaches need to be reported and how quickly they need to be reported. The enforcement rule is a protection rule that you will comply with investigations. And lastly, the Ombuds rule combines previous legislation. It is the most recent of the HIPAA regulations and rules, as new as 2009. This includes regulations that will manage the use of patient information in marketing, and includes a provision that requires healthcare providers to report data breaches that are deemed not harmful, making certain that business associates and subcontractors are liable for their own breaches. Electronic communication. So, can you share electronic communications? Can you text protected health information to a coworker or even your overseeing physician? What about emailing protected health information? Coworkers, physicians, and other healthcare providers are all considered separate entities, and each individual may have their own policy regarding sharing protected health information over text or email. So this is an important conversation to have, especially with your overseeing physician. Sending personal health information over institutional or organizational servers to another institution or organizational server that you know is encrypted is likely the safest option. Most regularly protected health information should be shared only on an encrypted system. Confidentiality exists in 2 contexts, either through legal or ethical contexts. Confidentiality is our duty essentially to the patients to maintain their confidentiality and anonymity through FERPA and HIPAA. The second context through ethics and our standard of care or our own personal health care philosophy. The latter of the 2 might be considered social support or even social confidentiality. Our patients must have a certain expectation of us to uphold the social support we provide them. We do not want to take protected information our patients confide in us and run and gossip to others, especially to colleagues, coaches, or even the layperson. This can be difficult because sometimes you need to use a second person to help you personally process through the information that was given to you. For example, if you were given information from an athlete that believed they had an STD, this might be the first time that you have ever experienced being given this type of information. Especially if you are new in your position, you may not want to break your patient's trust or confidentiality, but you may need help determining what to do and what resources are available. So you have to determine how to support the patient appropriately. There are 8 categories of social support according to Richmond, Rosenfield, and Hardy, and include listening support, Are you listening without giving advice and passing judgment? Emotional support. Are you providing compassion and caring to indicate you are on the patient's side? Reality confirmation. Does the patient have someone, maybe not necessarily you, that can help to provide reassurance? Task appreciation. Do you or others show support for the progress or action a patient has taken? Task challenge. Is the patient appropriately challenged in the way that they manage tasks to go a bit further? Tangible assistance includes appropriate financial or material assistance. Personal assistance may include helping with personal tasks such as driving someone home after a surgical procedure. These various areas of social support will not be used simultaneously. Most frequently, it is reported that our patients receive listening support and task appreciation reassurance from us as an athletic trainer. Patients are reported to expect the most listening and task appreciation from us. Dependent upon your institution, personal assistance may also be a norm, but please realize that it is not a norm at all institutions. So know what your duties are and know where to draw your boundaries.